Namaskar to all of you. I am coming to you after a long hiatus for various reasons. In this episode, I would like to discuss a few important legal aspects relating to contempt of court in the light of the Honorable Supreme Court sentencing senior lawyer Prashant Bhushan to pay a fine of 1 rupee or to face 3 months imprisonment and suspension of practice for 3 years. As you know, this issue of Prashant Bhushan's contempt of court because of 2 tweets he had made in June. One on the sitting Chief Justice of India sitting on a bike, a sports bike, without wearing a helmet. And the other one on the last 4 Chief Justices of India being corrupt. And the Supreme Court, when alerted by one of the citizens, initiated suo motu contempt of court proceedings. And what we have witnessed during the last few weeks has been a spectacle for those who wanted to support the freedom of speech and expression on one hand, and those who believe in retaining the sanctity of the institution of the judiciary as an institution. Whatever may be the case, Mr. Prashant Bhushan has been convicted for contempt of court under Article 129 of the Constitution of India by the Supreme Court. And even after the conviction, the 3 judges bench headed by Justice Arun Mishra gave him multiple opportunities to apologize for his comments and tweets. And Mr. Prashant Bhushan stuck to his guns, ultimately refused to apologize, stating that whatever he had said, it is in the larger interest of maintaining the sanctity of the judiciary as a whole and to ensure that its independence and integrity are preserved. And many critics say that Honorable Supreme Court should have left this particular incident untouched without initiating the suo motu contempt proceedings. But there are also substantial number of observers who feel that speaking on the past Chief Justices of the Supreme Court by attributing certain charges of corruption. Here corruption as stated by Prashant Bhushan is not accepting bribe alone, but compromising with the integrity of the institution. Probably, this should not go untouched or left undecided as per some of the observers. Be that as it may, that brings us to the power of the courts to punish for their own contempt in India. The constitutional courts alone are competent, that is Supreme Court and High Courts, though some of the tribunals are given the similar power under the Contempt of Courts Act. This is one important aspect. And even though it's difficult to trace this power, some people trace the power of contempt to the power of ecclesiastical courts in the past. The courts relating to religion. And from then onwards, the judiciary and the judges, they have been enjoying this power in order to protect and preserve their respect and confidence of the people. And the power which has been inherent and also specifically conferred under Articles 129 and 215 on the Supreme Court and High Courts respectively got supplemented by the enactment of the Contempt of Courts Act 1971. And there are two kinds of contempt. I need not elaborate. Here we are on criminal contempt. Criminal contempt normally denotes any act or any words or expressions which are likely to scandalize the court and its authority, or which tend to lower the image and authority of the courts in the eyes of the general public. Similarly, criminal contempt also denotes any attempt to prejudice or interfere with the judicial proceedings, or even with the undue influence exercised or that may be exercised on the courts and judges. This is the definition given under Section 2C of the Contempt of Courts Act. And over a period of time, since 1950 precisely, if we analyze the use of criminal contempt power by the Supreme Court and High Courts, we come across a plethora of judgments. I will try to mention a few of them in this episode. EMS Namboodripad, the venerated communist leader who was also Chief Minister of Kerala for a long time, was accused of making unfounded allegations against the judiciary as biased towards the capitalists, and he went to the extent of criticizing judiciary as a bourgeois institution which helps only the developed sections of the society and which is against the poorer sections. And when he was hauled up for contempt of court on the ground that he lowered the image of the judiciary by making such attributions, the Kerala High Court fined him to a tune of rupees 1000. Against the judgment of the Kerala High Court, he preferred an appeal. And in 1969 rather, Justice Hidayatullah led 3 judges bench let him off by reducing the fine to 250 rupees. But all along, EMS Namboodripad maintained that whatever he had said was already observed or commented upon by many of the leftist intellectuals. And his counsel made a vehement effort to justify his observations, his sayings, based on the leftist writings. But unfortunately, the exact statement could not be shown anywhere. Anyway, that was one interesting case. And it is equally surprising to note that Mr. P. Shivashankar, who was a lawyer turned judge turned politician, then minister also, he, while addressing an occasion relating to a bar association in Hyderabad, in Institute of Engineers, Hyderabad, sometime in 1980s, he made similar statements stating that the higher judiciary helps only the Matadhipadis, Jamindars, so on and so forth. And then he was also hauled up for contempt of court in PM Dua versus Shivashankar, 1988 Supreme Court. And Shivashankar defended himself, stating that he was also, in fact, talking about the class composition of the higher judiciary, because he was a champion of backward classes during his lifetime. And therefore, his statements should not be taken up or regarded as contempt of court. But he was not convicted for contempt of court, and the court held that his utterances did not amount to contempt of court. Almost almost similar situations but different judgments. This is one important aspect. You will also find other cases. For example, in Mulgaonkar case of 1978, the Indian Express article, which was dated 21st December 1977, which referred to the supposed code of judicial ethics wrongly assumed to have been drafted by some judges of Supreme Court. This is a quote. Similarly, the quote that the Supreme Court was packed by former Prime Minister Indira Gandhi with pliant and submissive judges except for few. This was the issue before the Supreme Court, whether these observations in the article amounted to contempt of court. Then, in fact, there were two orders passed, one by Justice Beg, who was the Chief Justice. The other one was Justice V.R. Krishnaiyer, who laid down 6 important principles relating to contempt of court. Today you can call it Magna Carta of Contempt of Court power. Like, under what circumstances the contempt of court proceedings can be initiated. One has to read the judgment in order to understand. That is, in re S. Mulgaonkar versus Respondent, 1978 Supreme Court. There have been any number of cases thereafter. Arundhati Roy made certain, caustic comments on the Supreme Court's judgment in Narmada Bachao Andolan case, talking about cow dung, urea, and their relevance to Supreme Court judges. Similarly, the relevance of money which is paid as compensation to the tribals who are displaced by these major projects. Ultimately, she initially refused to apologize. Thereafter, she was let off as part of the freedom of speech and expression, because her allegation was that the courts were insensitive to the plight of the tribes. Then Nandalal Balwani's case is one more, decided in 1999, but this was a classic case of contempt, where an advocate threw his slipper towards a sitting judge in the open court. And thereafter he said he was disturbed, police were harassing him, but the court did not find that funny. Ultimately, he was sentenced to imprisonment. And there are other cases also. For example, we have seen the case of Markandeya Kaju. Justice Markandeya Kaju, though he was a judge of the Supreme Court, had or maybe has the the attitude or habit of making some sensational comments. So he accused Gandhi as a British agent, Bose as a Japanese agent, so on and so forth. And he also said so many things about the Indian judiciary. He also didn't escape, at least from the contempt notice issued by the Supreme Court under Article 129. Then you can also refer to Blitz case, wherein the editor of the Blitz periodical, Karanjia, R.K. Karanjia, he was, in fact, found guilty of contempt of court by Justice V.M. Tharkunde, human rights champion, judge, and who imposed a certain fine by convicting the Blitz newspaper, in spite of arguments that what they were trying to do was to exercise their freedom of press. Then thereafter, in another journal, there was a news item called about the brother of the judge accepting some directorship from a company which initiated contempt proceedings against Blitz. And there they said that there was some kind of quid pro quo between the judge's brother and all. But the court convicted the editor for unnecessarily linking the brother's participation in the corporate sector to the decision of Justice V.M. Tharkunde. Then comes probably another classic, Justice C.S. Karnan's case, as you know very well. Justice Karnan, who was a judge of the Madras High Court initially, thereafter he was transferred to Calcutta High Court, and in Calcutta High Court after some time he was not allotted any work. then his actions, his orders, his utterances, ultimately the issues raised by him. Honestly speaking, some of the issues raised by Justice Karnan while in Madras High Court, they merit serious consideration. But the way they were raised and the way the cases were transferred to oneself by one's own order, similarly staying the transfer of his own transfer from Madras High Court to Calcutta High Court, thereafter issuing notices to the Supreme Court judges themselves, then initiating proceedings under the Atrocities Act of 1989. So many things were involved in that, and there also he was given multiple opportunities to appear before the court. His lawyer Matthew Nedumbara, he made a fervent plea in the Supreme Court late thereafter. Even after his conviction in the Delhi High Court also there was a petition filed. But ultimately Justice Karnan had to spend 6 months in jail because of contempt of court. And it is very unfortunate. Probably it is something which shouldn't have happened. Anyway, that is one aspect. Then we also come across what happened in January 2018. 4 senior judges, part of the Supreme Court's collegium, holding a press conference, making serious allegations against the then Chief Justice about the allotment of cases and all. So that hit the headlines. Probably they might have thought that they have done a great justice to the independence of judiciary. Many people think that probably they have diluted the standards or the integrity of the judiciary that way. This way or that way, all the 4 judges are retired today. Some of them had personal grouses, that's what they say. One of them at least could have become the Chief Justice of India if on the same day he was given the due seniority to which he was rightfully entitled. But they raised some pertinent questions. Unfortunately, the internal mechanism was not used. Then the Supreme Court had to give a judgment saying that the Chief Justice of India is the primus inter partes. So, he is the first among equals. So, he has every power to allot any kind of judicial work to his brother judges. Now comes Prashant Bhushan case. You know very well, Prashant Bhushan has been a very vocal advocate, and probably his background, his father being a former law minister and an activist advocate, very senior advocate, highly respected, Mr. Shanti Bhushan. Whatever may be the case, the Supreme Court ultimately found him guilty, but the fact is that the Supreme Court was trying desperately not to convict him. Even after conviction, not to sentence him, which can be seen from the sequence of events. And ultimately, the Supreme Court had to, convict him and award a fine, impose a fine of ₹1. I am reminded of a judgment given in England way back in 1703 in a case called Ashby versus White. We say it is one of the most important cases in law of torts, where the right to vote was denied without any reason. Even though the candidate for whom the candidate wanted to vote, the voter wanted to exercise his vote, won the election, still in recognition of that right, the court then awarded nominal damages. This serves 2 purposes. One, to drive home the point that the person has crossed the Lakshman Rekha. Therefore, he is guilty. The second one is that maybe, in view of the peculiar circumstances, some pinch must be there, if not a heavy pinch. Therefore, negligible amount of, in fact, a fine, penalty. Same thing happened in the instant case. Many editorials criticized the Supreme Court, saying that he should have been left alone. But the point is very simple. No institution will be as tolerant as the judiciary. Honestly speaking, we are living in an age where the governments of the day are not tolerant about any criticism made against them, which is legitimate also. We have seen the use of police by the governments. I don't want to name them. It may be at the central level or the state level. If anybody says anything against them, certainly there will be repercussions. If political organs are going to that extent, why should the judiciary become a silent spectator? Especially when, even though with the good intentions, someone makes serious allegations, and in fact, someone makes or attributes insinuations and innuendos. That's what we say. That which are difficult to prove. If it is really possible, then let there be impeachment. But without resorting to that, certainly we are not doing any great favor to the, in fact, the independence of judiciary and the credibility of judges. We are not saying that the judges are above the board, but at the same time, the judges must be left alone in certain cases. Maybe it is also one of the reasons. In the good old days, people used to say that judges should live like hermits. Today, they think that they are part of the active society. This hobnobbing with the all and mighty, the celebrities, the society, the social media also has its own drawbacks. Maybe this is one of them. So ultimately what we have to say is only this much. I am reminded of the great words of Lord Atkin in a case called Henry Paul versus AG of Trinidad, decided in 1936 by Judicial Committee of the Privy Council, who said that justice is not a cloistered virtue. She must be allowed to suffer the scrutiny, though outspoken comments of ordinary men. So time has come because of the advantage of internet, the availability of multiple fora, in the actual world and virtual world. These comments are bound to be made. The only thing is Lakshman Rekha has to be drawn somewhere, because my freedom stops where tip of your nose begins. I think this point must be remembered, because advocates are also officers of the court. They also have equal amount of responsibility to uphold the integrity, the character and the exalted position of the judiciary. But it doesn't give license to the judges to be licentious. That is another important point. So judges also must be above board in order not to attract these comments. But if there is anything unreasonable, if it is not beyond the Lakshman Rekha, ignorance is the best option. So let's hope that the episodes like Justice Karnan, Mr. EMS Namboodripad, or P. Shivashankar, or Prashant Bhushan, or even revolt by 4 senior judges, as the Supreme Court said, will be the things of the past, so that the confidence of the people will be reconfirmed, reaffirmed in the great institution of judiciary. Thank you very much. My purpose is only to drive home the journey of the contempt power and its usage since 1950 till today. We shall meet in the next episode. Until then, stay safe, take care.